Thank you very much. So on to our main event and where we will be handing over to the better judgment of our three very esteemed guest speakers, Nicola Harries, Jacqueline McKenzie, and Nadine Finch. So essentially, we're having this discussion because there's a lot of correlation between these three acts being direct attacks on our democratic rights. And basically, we wanted to have this discussion for, not just the Caribbean community, but for the wider British community, because these proposed acts are obviously going to be very much limitations and attacks on our democratic rights, affecting things such as citizenship and the simple ability to protest and then some. So essentially, I'd like to welcome our three guest speakers, one being Nicola Harries, who is a solicitor for Goodman Ray, admitted in 1979, who specializes in children's law and amongst other areas. Another of our guest speakers, Nadine Finch, is one of our CLS exec members, and we're very glad to have her here. Nadine is also a lawyer who specializes in children's rights and human trafficking, and is an honorary senior policy fellow at the University of Bristol. And of course, Jackie McKenzie, who I'm sure many people have heard of from dealing with cases that have affected the British Caribbean community to do with and also preceding the Windrush scandal. Jackie McKenzie is a very experienced immigration lawyer and a partner of law firm Lee Day. So we're very, very grateful to have a trio of heavy hitters speaking for us today on these attacks on our democratic rights. And I'd like to hand over to our guest speakers to please present for us and offer comment on the topic at hand. So please, over to you, whomever would wish to speak first.
Omar, I think you have to be better if you put them in order.
Yeah, sure. Absolutely. Nicola, if you'd like to please go ahead, actually, please feel free to present for us. And we're very grateful to have you here today. And Nadine, if you'd like to go second, and then Jackie, if you'd like to close off for us, that would be much appreciated. Thank you.
Thank you, Omar, and thank you all for inviting me to speak to you today about the Police Crime Sentencing and Courts Bill. As Omar said, I've been involved in the law since 1979. I'm no longer in full-time practice, and I'm definitely still learning. For the last 2 years, I've been actively involved with Extinction Rebellion and the ever-increasing minefield of protest law. This bill first appeared before the Commons in March 2021. As its name implies, it covers a very wide range of subjects, far too many to detail in this short talk today. But it's the clauses that impact on our rights to protest that I want to consider with you this afternoon. To consider the practical implications of these proposed new laws, I want to look at it on the ground. For some reason, this government really dislikes one-person protests that often take place right outside Parliament. And apparently the main offender was a specific individual who protested on a daily basis over a very long period of time and in a very loud manner against Brexit. So if this bill is enacted and you want to exercise your democratic right to stand outside Westminster on your own with a placard, make sure you do not have a drum, beatbox, or any other sound equipment that would entitle a senior police officer to place conditions on your protest, which, if not complied with, could result in your arrest and charge under the amended Public Order Act to incur a large fine and or possibly 51 weeks in prison. And if you were passing by and gave words of encouragement, you could be guilty of an offence of inciting the protester to engage in his one-person protest. How absurd is that? Incidentally, this bill also seeks to limit specific protest activities that impede vehicles in a specially prescribed buffer zone area around Parliament. Surely the seat of government is an obvious place where protesters wish to make their protest heard. But it's more likely that you'd be protesting in a group. So under this new landscape, there'll be new powers given to the police to place conditions on the right to public processions and assemblies, but this bill does not detail what those conditions might be. Because most protests are noisy, the police will have the power to determine whether the level of noise is such that it could cause, and I quote, serious disruption to the activities of an organisation which are carried on in the vicinity of the procession, or such that they may be a relevant or significant impact on persons in the vicinity. The very nature of protest is it's noisy, whether through chanting, shouting, samba drumming, or amplified musical support. So the police, having put into place their own conditions on the protest assembly or procession, may immediately arrest protesters who do not comply. And it gets worse. At the moment, it's currently possible to successfully defend a charge arising out of an alleged breach of a police-imposed condition by claiming lack of knowledge of the conditions. This bill would disallow this defence by making it an offence where the person ought to have known of the conditions, so effectively criminalising protesters who inadvertently commit a breach by being in the wrong place at the wrong time. Sorry, I just lost my writing. So, I'm sorry, everyone. Anyone who takes part in a noisy protest in Trafalgar Square, which continues down Whitehall, still shouting and chanting, may actually commit an offence of failing to comply with conditions which had just been imposed by the police and be guilty of that offence because they should have known, even though they clearly didn't. You might have a successful challenge in court, but your protest has effectively been curtailed on that day, and you have to undergo the whole arrest and court procedure. You could have been out in London for the day, seen a protest taking place, let's say, against the draconian Nationality and Borders Bill, which you will know as the anti-refugee bill, and have decided on the spur of the moment to lend your voice to the cause. You could quite possibly end up arrested and even with a criminal record, which could have devastating effects on your future. And for the average citizen, it's a risk not worth taking. And thus these provisions and others that I'm going to discuss later will have what is now termed a chilling effect. They act as a deterrent to the democratic right to peaceful, if noisy, protest. This is what this government wants, an end to these noisy, disruptive protests. It makes no secret of the fact these changes to the law are motivated by their dislike of the BLM and XR protests last year. And who cares what human rights are contravened? The police are to be given wide-ranging, as yet undefined powers to decide when to impose restrictions, but even now they find it difficult to understand how to exercise their current powers. It's unrealistic to assume that officers, often following police guidance and handbooks, will fare any better when their powers are increased as proposed by the bill. The Home Secretary clearly stated that the police want more powers to restrict protest. Yet an open letter signed by former police officers and chiefs was sent to the Home Secretary after the publication of the bill, saying that the proposed clauses represent a threat to democracy. And further inquiries by Liberty and Friends of the Earth, using the Freedom of Information provisions revealed in July 2021, that the Police Federation and Association of Police and Crime Commissioners had not been consulted on the protest measures of the bill. Lord Paddock, who was formerly Assistant Commissioner of the Metropolitan Police, has stated that he considers it will be very damaging for police public relations, which we all know are at an all-time low, if the police are seen to be an instrument of the government. The police's use of force during the vigil for Sarah Everard, the woman murdered by a serving police officer in March 2021, and during the Bristol protests to kill the bill, and some extremely unpleasant incidents of overzealous policing during Extinction Rebellion protests in London last summer, reinforce the very real concern that to give the police more powers will deter peaceful protesters from exercising their rights. Surely the duty of the police is to support and promote the right to peaceful protest, but recent events give the public no confidence that such rights will be upheld, rather the reverse. This bill will give the police powers they don't need. They have quite sufficient already under the existing Public Order Act. Another serious concern is that the proposed clause that gives the Home Secretary the power to make regulations defining what would amount to serious disruption to the activities of an organisation or serious disruption to the life of the community. So the Home Secretary would have an expansive power to declare the kind of protests and causes it deems inconvenient or unacceptable and provide the police with a licence to limit them. Liberty has referred to this clause as demonstrating the increasing propensity of this government to evade parliamentary scrutiny. Others might suggest it is a move towards authoritarianism. Union activities such as pickets and protests outside places of work may be impacted by these proposed changes. By relying on the serious disruption to the activities of organisations, these powers could be used to clamp down on commonplace union activity. As you all undoubtedly know, the right to picket and protest is a fundamental human right that has been seriously eroded over recent decades. And Lord Hendy, a champion of trade union rights, raised this issue in the recent House of Lords debate in November, stating that the proposed clause will give the police the power in many sectors virtually to extinguish life from the remains of this emaciated right. And then there was Insulate Britain. Once again, the Home Secretary seeks to bring down her iron fist and so introduces more than 15 new pages of amendments to the bill while it's going through its report stage in the House of Lords as recently as the 15th of November. A knee-jerk reaction, or carefully orchestrated to enable this deeply unpopular bill to be hastened onto the statute book? These very recent amendments cannot be included in the current bill if the Lords vote against them, hence the sudden spurt of activity among protest groups across the land. Liberty has stated these new clauses threaten to extinguish a crucial means by which people can stand up to power. Let's be clear, bringing in any of these further changes to the current law will not discourage the hardened, committed activists, such as those who return to sit on the M25 day after day, knowing their actions would lead to their imprisonment. They will act according to their conscience and take the consequences. However, one of the proposed amendments is to include imprisonment as a possible penalty for willful obstruction of the highway, previously only punishable by a fine. Big protests through the streets of London often result in willful obstruction, which, when the worst consequences were a small fine, was a risk some protesters considered to be worth taking. But these new provisions could well have a chilling effect on an individual's exercise of their right to protest. Let's look at another example, a lock-on protest, perhaps not one that you've seen where someone uses a specific device to attach to the railings outside Downing Street, but where perhaps people lock arms together or attach their wheelchair to a traffic light during a disability rights campaign. They could be guilty of this new offence if such locking on causes serious disruption to two or more people or an organisation in a public place. Breach of this offence carries a larger fine and or 51 weeks imprisonment. Once again, the risk is this will act as a deterrent to protesters who are not seeking to block the M25, but simply to draw attention to their particular campaign. If you're carrying something that might be used in a lock-on, the police will have new powers to stop and search anyone they think might have such objects on their person and arrest you for having that offending object. I can give you a very specific example that happened only last month. Your very own Steve Cushion went, I have to say at my instigation, to see how the protest outside the Edmonton incinerator was faring. He was stopped and searched, and although verbally told by the officer he was looking for items that could be used for lock-on, bear in mind this provision is not even law yet, although when he was given the slip, it stated they were looking for items that could be used for criminal damage. And that is in fact lawful at the moment for the police officer to make that search. But if Steve had had a bike lock or super glue he'd purchased for a DIY job in his rucksack, under the new laws, if enacted, he would have been dragged through the criminal justice system. The police will also have greater powers to stop and search for anything they think might be used in connection with obstruction of the highway or public nuisance. So if you have banners, posters, placards, these could be seized. How is this going to encourage people, particularly from marginalised communities, who are already exposed to over-policing and excessive use of stop and search, to want to exercise their right to protest? Apparently even the police don't want this. One officer was quoted in a recent report about stop and search to say that a little inconvenience is more acceptable than a police state. Criminal Justice Alliance spoke to young BAME people with first-hand experience of stop and search, and they described feeling harassed, targeted, provoked, and even violated by these coercive encounters. You may have personal experiences of these responses. And these inequalities will only be further entrenched if these provisions become law. A new offence will arrive onto the statute books with these new amendments. A person will commit an offence if they protest if the protest in which they participate interferes with the construction of or maintenance of infrastructure such as airports, roads, railways, oil refineries, printing presses. Again, it carries a fine and possible imprisonment of up to 51 weeks and could be applied to industrial action taken by union members picketing against any of these industries. The consequences are dire for all of our rights in a functioning democracy. And finally, these new serious disruption prevention orders. They are a new civil order that can be imposed on individuals who've participated in at least 2 protests within a 5-year period, either on conviction or without conviction. The order can last from a week to up to 2 years, carries conditions to which the person will be subject, such as limit association, where the person can be, not to have certain articles in their possession, even restricting their use of the internet. The order, although civil, carries criminal penalties if breached, once again heavy fine or imprisonment for up to a year. Such an order will effectively amount to a ban on the fundamental right to protest and participate in a political community for that person. It cannot possibly be compatible with human rights legislation and marks a significant expansion of state surveillance of those who protest. I'm going to end this whistle-stop tour of the PCSC bill by quoting Lord Rosser, a Labour peer, from his speech in the House of Lords during their debate just 6 weeks ago on the 24th of November. It is our belief the powers in the bill threaten the fundamental balance between the police and the people. The most severe clauses are not actually what the police asked for. We believe these new, broad and vaguely worded proposals would impede the ability of the police rather than help them in their job. And these clauses put way too much power into the hands of the Home Secretary. The powers threaten our fundamental right to peaceful protest. This bill has its final reading in the House of Lords on the 17th of January, and let us hope that that was not a lone voice of opposition. Thank you.
Nicola, thank you very much for presenting the realities of the police bill passing. What we'll do is we will hold off on any questions for the time being until all of our speakers have presented. But thank you very, very much for breaking that down. It's a very, very scary piece of legislation, and we all need to get behind doing what we can to applying pressure to stopping it from passing. And I'm hoping that it doesn't get to that stage. I'd like to move on to our next speaker after that fantastic presentation by Nicola, to our very own Nadine Finch, who is one of our EC members. So I'm very, very glad to have Nadine here with us today presenting, and basically, yeah, very thankful for that fact. So Nadine, over to you.
Thanks, Omar, and thanks to CLS for inviting me, and welcome to the many campaigners and lawyers I've seen in the chat and in the participants. Omar talked about me being a children's rights lawyer, but actually I was also a public law lawyer. And many of the things which Nicola has just gone through has a real resonance to me. And I'm just mentioning 2 or 3 of them. I used to give pro bono advice to Stop the War Coalition. And we had to negotiate with the police about many of the huge marches that they organised. And it was very noticeable that police usually cooperated, because as far as they were concerned, getting self-regulation of marches and getting good stewards who knew the people was a really good thing. And if you notice on Stop the War March, there were very few police officers. I think a lot of the police officers that we negotiated with would be really appalled by the new draconian measures being introduced, because they tend to lead to violence. They tend to lead to people thinking they have no other option but to take up violent means. People who are old enough to have been involved in the miners' strike know exactly what happened when the police moved into the villages in Yorkshire and went way beyond the law, or new bylaws were brought in. It engendered violence. I'm actually from Northern Ireland, my parents from Northern Ireland, and I know exactly what happened when draconian measures were put for 3 decades in Northern Ireland. It's not the way to encourage people to accept democratic means of protest. It's exactly the opposite. And I'm very concerned as a lawyer, and some of you will know I also was an immigration judge for a number of years. As a lawyer and a judge, I am extremely glad I'm not practicing anymore as a judge or as an active lawyer, because I would find it incredibly difficult to implement many of the laws now being put in the statute book. And I expect that many others will also be equally concerned. But to turn to the Human Rights Act and its abolition, just to explain the Human Rights Act, what it does is bring the European Convention of Human Rights into British law, because British law is very different to European law and very different to American law. It's not, it's a coalition of acts, but also most of it is built up by case law. And it's, we don't, the UK doesn't accept international law. We may sign treaties, we may sign conventions, but they don't become part of our law unless we incorporate it. So the Human Rights Act incorporated the European Convention of Human Rights, which was part of the reason the populists in charge of the government at the moment don't like it, because for them it's an alien, it's an other type of law. It's the kind of law practiced in Europe, which is completely different from us because it tells people things, whereas they seem to believe that our laws don't tell people things. So what they're proposing is to repeal the Human Rights Act, which they see as an alien kind of law, and to replace it with what's called the modern Bill of Rights. And there's a consultation paper which was slipped out just before Christmas, and there's 3 months to reply to it. And I would hope that the CLS does try to reply to it. I'll come back to it. It's a very difficult consultation, because the first time I read it as a lawyer, I just was confused, because it's actually written by populists thinking they know about the law. I'll come back to that in a moment. But explain about the Human Rights Act and why in particular I think the present government doesn't like it. Is the Human Rights Act was brought in to enhance rights for everybody. But of course, in an unequal society, certain people have many more rights. So not surprisingly, the Human Rights Act's been used by lawyers like myself, and I'm sure by Nicola, over the years to help people who didn't have enough rights. So travellers, roamers, prisoners, migrants, very much migrants, and other minorities. So the majority of Human Rights Act cases which came up either through judicial review or other mechanisms did involve minorities. But that wasn't a surprise, because those were the minorities who were denied usual rights in British law. Now, as I said, as a lawyer and judge, I'm horrified by the proposal, not only in the acts we're going to talk about today, but also this proposal for a modern Bill of Rights. But I slightly query the title of this session today, which is Resist the Legal Attacks, because actually attacks are really on the law. They're not so much on legality, because as people know who study any kind of revolutions or any kind of, whether it's in the Caribbean or Latin America or Central America and Ireland, judges and lawyers quite often are the last people standing. And the idea to abolish the Human Rights Act and replace it with a very much weakened Bill of Rights is that they know that people aren't going to accept the changes to the policing bill or to the tax in the Nationality and Borders bill. They're going to go to the law, they're going to go to lawyers, they're going to hope that judges assist them. So at the same time, they have to use other means to weaken the protection of the law. So in many ways, the modern Bill of Rights is an attack on lawyers and judges. Because the present government and the present House of Parliament has a staggering amount of lobbyists and businessmen, very few lawyers, or practicing lawyers, a few people who became barristers on a way to being an MP, but in fact, we have an increasingly unbalanced House of Commons. House of Lords is slightly better, in that people there really only know about lobbying and business. And they also are breathtakingly dismissive of any kind of professional, whether it's a doctor in the present pandemic, or whether it's a judge, or whether it's a lawyer, whether it's any kind of scientist. And that's a background that stands behind the proposal. Now, that's not to say lawyers and judges aren't also affected by their class, by their race, and even by their religion in Northern Ireland. But most of them have been trained and have grown up in a system where there are certain parameters, legal parameters, and they've learned to play by certain rules. What's happening with the acts we're talking about and with the proposal of this Bill of Rights is that those traditional rules are being thrown aside, because above all, this is a deregulating government, a government which just wants to strip away any rights so that their business pals, and they particularly, whatever their particular bone of contention is, can just go ahead without any kind of checks and balances. And it's important to remember that when we're talking about these acts. And it may well be, and lots of people are saying that because they are stripping away legal rights, that the communities themselves will have to bring their own kind of rights into existence. It's notable in a government which cannot come to terms with the pandemic and the serious effect it has on the elderly, disabled and minorities, that communities themselves have actually formed mutual aid, and they've formed their own ways of coping with it. It may well be, as law is being attacked by the government, that people may have to have mutual aid in a different kind of way to protect people's right to protest and people's right to actually live a lawful life. I'm trying to be not as legalistic as I could be, but one of the problems is that this government doesn't like lawyers, so it's going right back. So when you read the consultation, and it's a difficult read, they're basing it on things like the Magna Carta and the 17th century Bill of Rights. Now, these are not the foundations of our system. They're not the foundations of our law. They were a lot of MPs who were landed gentry seeking to curtail the powers of the monarch. They weren't democratic. They didn't bring in rights for trade unions, rights for people who worked in the fields. They were to protect Parliament. And in some way, they've come a full circle, because the Bill of Rights is, again, this so-called modern Bill of Rights is actually the old Bill of Rights protecting Parliament, because a huge amount of the content of the consultation is all about how Parliament has the right to rule without any kind of check from people from lawyers, from judges. And it's important to put it in that context. And you will see the way recently, I just give 2 examples of how they attacked lawyers that had the temerity to stand up to them. One is a well-known case brought by a Guyanese woman about Brexit. It was whether or not the government had the right to go ahead on Brexit without bringing it to the full parliament. Now, those 3 High Court judges who decided that no, they had to go through the whole proper process were pilloried in the press like the Daily Mail and called enemies of the people. Now, I actually talked to one of those judges, who's not by any means a left-wing judge, but he was truly horrified and also frightened by that, because that Daily Mail and other papers were all over. He was scared for himself, for his children, and also having spent his life in the law, he was truly worried for the future. But even as an immigration judge, I appeared, unfortunately, in the Sun a couple of times when I had allowed an appeal from the migrants who they wanted to deport, even though they had committed a crime as a young person and had spent many years since then. And those kind of attacks by the press are very important because they do have a chilling effect on lawyers and judges. They make people think, should I really say this? Should I really go that far? And that worries me also about these proposals. Now, to come back to what the contents were in the Human Rights Act, the contents of the Human Rights Act were not economic and social rights. Sometimes you think when you hear the government, they didn't give anybody a social or economic right. They gave people some limited civil and political rights. And some judges and some lawyers use those in a good way, in a imaginative way, to bring more rights for people. But it was always a struggle. And as I say, an awful lot of the cases coming forward were about migrants, because our immigration law, way before the Nationality and Borders Bill, has always been very discriminatory, and increasingly so through the last 30, 40 years. But so it means that in the Human Rights Act, people use the right to family life, a very basic right. And that right to family life is going to be severely curtailed in the new so-called Bill of Rights. In fact, it's instructive to look at the rights that are being highlighted in this new Bill of Rights, which are nothing to do with individuals and democracy, but all to do with assisting this government. One of the notable things is that one of the highlights of it is the right to free expression. But this is not free expression to go and protest. It's not the free expression for Jeremy Corbyn to talk about defending Palestinian rights. It's not the free expression of Julian Assange to assist in knowing what happened in Iraq. It's about Daily Mail journalists being able to say what the hell they like, not because of freedom of the press, but because it assists the people in power. I'm sure lots of you will agree with me, we don't really have a free press now. There's a lot of talk in the Bill of Rights about protecting our wonderful free press, protecting the right of expression. The expression that's being protected is merely people with money and power to say what they like about other people when it is of their use, for instance, in Brexit or around COVID. So that's one of the things which is being highlighted quite disingenuously. There is nothing about the freedom to protest. There's nothing about the freedom to protect minorities. There's nothing about the freedom of people such as the Roma to leave their life as a culture is necessary to do. And of course, there's nothing about race, probably nowhere in the Bill of Rights, because it's purely going back to the 19th century when it was a colonial state. And there may have been a few black people here, but they were just happened to be here because of colonization. So it's very much an old-fashioned Bill of Rights for people in power. It's also interesting that they do mention the Representation of the People Act in the introduction, but the one they actually mention is the 1918 one, which of course didn't give the vote to women under 30 and didn't give the vote to all people. It men of property and women of property. So it's quite interesting they picked on that representation. Now, Nicola covered very well the right to protest. And then Dermot talked very well about the recent trial down in Bristol. And I would just add a bit to what Dermot said. If you're a lawyer, there's a huge amount of discussion about jury trials and the right to jury trial. And I don't know any lawyers who seriously doubt that juries are a good thing. Juries are a good thing because they give a bulwark against the fact that there is a class bias in the class of lawyers and judges, because to get educated, that's you're likely to have come or been privileged in some way to get to that. The good thing about juries is that it is of your peers. You could say it is slightly postcode lottery. If you appear at Snaresbrook, you are much more likely to get off than if you appear at Kingston, for instance. Even the Old Bailey has an interesting get-off rate because of its catchment area. I actually once attended a trial and I was a pupil barrister, and the man's defence was, I did make bombs, but I only made bombs to be used in Ireland, not in England. And the jury acquitted him. Juries do acquit them. There was also a very similar to the Colston trial. There was a trial also done by some of the Garden Court lawyers, actually, about GM crops in Norfolk, where I can't remember his name. The guy's he's a peer, he's a kind of trendy hippie peer who's in the House of Lords, who went and destroyed all these GM crops in Norfolk. And their defence was very similar to the one in Bristol. Yes, we did it, but we were justified in doing it. So juries do that. And it's a very important thing that juries are able to do that. And the interesting thing, which the press and all the many non-lawyer MPs commenting, is that the only appeal against decision in a jury trial is if the judge so blatantly misdirected the jury that they came to the wrong decision. You cannot touch the decision by the jury. You can only touch whether, and as far as I can tell, the judge down in Bristol, who is a quite an experienced judge, was very, very careful in his directions. He gave numerous directions because he knew it would be appealed by this government. And so the jury trial is really important. I know Dermot and people are very right. I think they could try and reverse on the right to jury trial, but actually they've made such a song and dance about it as being a fundamentally British part of our heritage throughout the consultation on the new Bill of Rights. They'd be in real difficulties doing so because of the three things. That is a big thing for them. They're a bit disingenuous because in fact we don't have the right to jury trial in all criminal cases. It still doesn't exist in Northern Ireland. They can still take juries away from certain classes of people they'd consider terrorists or others in Northern Ireland. So it's not quite right to say, which they are saying, that there is a complete right to jury trial. But I think I'm hopeful they're going to be in difficulties over the jury trial in Bristol because of the song and dance they've made about it. But I think when we talk about the other acts, it's important to think the background to the Human Rights Act is an attack on, undoubtedly attack on migrants, because they feel that Article 8 and 3 have been used to get round what they see as obvious needs to deport people. But it's also, as was said at the beginning, an attack on other people, because it's not just migrants, it's anybody who is discriminated against in the society that's had to fall back on the Human Rights Act. And that's what they want to get rid of. And it is definitely worth a look, and it's worth people like CLS attempting to answer at least some of the questions. But I'll finish on the fact that the very legalistic parts of the Consultation Human Rights Act are also very important, because just as the right to jury trial is undermined by the fact we don't have proper legal aid system anymore, and that we have such a creaking criminal justice system that people are waiting 2-3 years to get into court. They're also suggesting introducing what sounds quite innocuous. It's a permission stage before you can bring a human rights claim. Now, we already have permission stages in judicial review, and as the judge who did judicial review, we dealt with them on paper quite quickly. And if there was absolutely no basis, they wouldn't get to the much further, but people could still come back and argue. But this permission stage is very different, which they're suggesting both for judicial review and for all other cases where you raise a human right. And that is that the person must have suffered a significant disadvantage. And it goes back to some of the phrases Nicola was referring to. These sound legalistic and they sound clear, but in fact, significant disadvantage is an incredibly complex legal test. And it will undoubtedly stop a huge amount of people being able to bring Human Rights Act claims. Because it's unclear what kind of legal aid these people will have anyway to bring these cases. But a layperson, what's significant mean? What's disadvantage mean? What's having suffered? What level of suffering? I mean, these kind of cases have excised the best judges in the European Court of Human Rights since the last 40, 50 years. They're incredibly difficult concepts. They've been put in there on purpose to make access to human rights incredibly difficult. There's also a fallback position, which is also, you could show that something had overriding public importance. But this is a phrase already used in law when I've struggled with both as a lawyer and a judge. Yet again, what's overriding? What's public importance? They're concepts which are going to make it incredibly difficult for ordinary people. And by ordinary people, I was just thinking very quickly of things which did affect the Afro-Caribbean community, particularly in judicial review. Many people from minority groups, whether they are migrants or settled community, bring human rights cases about children being placed in immigration detention because the government thinks they're adults when they're children. They're about adult migrants who may be suffering schizophrenia, who've been stuck in an immigration detention centre for years. They're Black or Irish kids being detained by the police who want to bring cases for wrongful arrest and wrongful detention. Now, they're characterised in this debate by the government as people just wanting to make money from the government. But in fact, I used to do a lot of cases against the police. And you don't really get much money, but you do get a sense of somehow understanding your place in the world and realising that you have some power against the state. So being able to bring actions and bring actions with damage is not about money. It's about people feeling they have some power in the society. And the last category I thought about is there are many people in African community who are ill-treated in the mental health system. And one of the ways they can actually hit back, or the families can hit back, is to take a human rights application. My view is that in the new modern Bill of Rights, it will be very, very difficult for them to do that, because they'll be characterized as one person who's ill, doctors have helped. I think there's a huge amount of real worries about the Bill of Rights. It's being slipped in over Christmas. It's very difficult to follow. It makes you very angry if a lawyer, and a lawyer here is trying to read it, because it is deceitful. But it's also, we already have 4 or 5 things. We've got the Nationality and Borders Bill, we've got the Policing Bill just finishing, we've got stuff about not allowing people to vote without ID, when we know the Electoral Commission says that will affect the Black community more than anybody else. And I haven't even mentioned, and I will mention in closing, we also have an act coming in, bill coming in, which will, that's amazingly, well, not amazing for this government, there are a number of inquiries, inquests, and judicial reviews still going in Northern Ireland to do with deaths by military service and by loyalist paramilitaries in the 30 years after 1970. The proposal in this act is to stop the ability of any lawyer to bring a case, the police service in Northern Ireland to investigate a case, and the judges to hear a case. And they're also suggesting that they will stop inquests, inquiries, and investigations that are already halfway through or started. They will just rewrite history that 30 years didn't happen. It may be just about Northern Ireland, but it has a very worrying effect for what other things they can do to whole groups of people. They could suddenly decide, for instance, here that they wouldn't allow inquests into death in custody throughout the UK after a certain amount of years. The proposals by this government are far-reaching and incredibly worrying for any lawyer and any ordinary person. It's difficult to tell. This government, in one level, is very incompetent. On another level, it's frighteningly like what's happening in Hungary and Poland. You may or may not know that in Hungary and Poland, they've actually just dismissed loads of judges and lawyers who objected to them. And I rather fear we're going that way with this Bill of Rights. Thank you.
Nadine, thank you very much for providing us with a very detailed breakdown of what human rights, the Human Rights Act entails and what it means. It's a very, very scary time that we're living in. Effectively, the human rights of Black and brown individuals are constantly under threat, and especially those from the GRT community, as well as the Black community. So we must stand in solidarity together in tackling these attacks and infringements on our human rights. There's a lot of action that we can take as a collective community. I've put in a letter that got sent off to the House of Lords that was signed by CLS and 100 other organizations. I'm aware that there was a second letter that also went out to the House of Lords in tackling Clause 9 of the Nationality and Borders Bill. We received, well, the public have received a response from the government regarding Clause 9, and government have decided that they do not wish to remove this from the Nationality and Borders Bill, which is a huge problem within itself. The petition has been signed by over 300,000 people. However, we'll circle back to that one later on. I'd like to pass on to our final esteemed guest speaker, Jackie McKenzie, who I'm very, very proud to have here with us alongside Nadine and Nicola. So Jackie, I'd like to pass over to you, who is in sunny Grenada at the moment.
Thank you, Omar, from sunny Grenada. Thank you for your introduction earlier. And good afternoon to members of Caribbean Labour Solidarity, CLS, your audience, and also to the esteemed speakers whose company I'm honoured to be in. One of the very first immigration cases I ever did when I was newly qualified and practicing at Burnbed Peer Solicitors was with Nadine, who was then practicing at Garden Court Chambers. So it's an honour to be in your company here today. I've been asked to say a few words about the Nationality and Borders Bill. I can't actually imagine that anyone associated with CLS or who takes time out on a Sunday to attend a political meeting heavily invested in the issues and concerns regarding the bill, but it's important, and I'm extremely grateful to CLS for doing so. The Nationality and Borders Bill will form a comprehensive piece of legislation and changes, significant changes to immigration law, heralding in changes unlike anything we'd seen since major changes in, I think it was July 2012, which affected large numbers of people and brought in some really draconian things around private life and family life, and no recourse to public funds, etc. And of course, the changes we saw with the impact of the EU withdrawal on 4 million EU citizens. And just by way of a bit of background, the bill was introduced in the House of Commons by our current Home Secretary. I mean, I think that alone tells you, even if you've not read it or not even heard of it, that alone should probably tell you, what this bill's about. But Priti Patel's idea was to make the hostile environment, ironically now renamed the compliant environment, following the Windrush scandal, even more hostile than anything we'd seen before. So in July this year, or last year rather, the bill was introduced, and then our major concerns were about the impact the bill was going to have on people seeking asylum and people who had been trafficked. The government said at the time it was to tackle illegal migration and people smugglers. But experts who looked at the bill very closely found no evidence in it that it could actually achieve any of those things. I'm just looking for some statistics that I've got in front of me. Well, can't find them, never mind. And so this reminds us that the hostile environment, heralded in by both Labour and Conservative governments, were both posited on the basis of stemming illegal migration or illegal immigration. But the biggest group of people known to have been affected by it appears to have been people who in the UK as lawful citizens, i.e. those of the Windrush generation. So we've heard all of this stuff before about stemming illegal migration and having policies to do so, and the wrong groups of people being caught up in it. We didn't trust them then, and we shouldn't be trusting governments now. Refugee Action described the bill as effectively closing the door on desperate people who arrive in the UK to seek safety. Their findings is that under the bill, only those arriving through extraordinarily restricted official routes will be allowed to claim protection, and we already know that those routes do not exist. We saw earlier on this year the closure of the Syrian program.
How far you got, Nathan?
And we also saw a rejection of the Dubs Amendment. One of the very awful provisions in the bill is the proposal to process asylum seekers in offshore centres in countries including Rwanda and Albania, even though both those countries denied having any such agreement with the British government. Effectively, the Home Secretary seemed to have just made up a story. And despite also the UNHCR condemning any attempt to do this and pointing to the case of Albania, of significant human rights abuses evident in their lone immigration centre, and comparing that to the experiences of people in Australia who are placed in offshore centres where there's been cases of sexual abuse, rapes, significant human rights abuses, and there have even been deaths. But none of this has deterred our Home Secretary, who seemed to be looking for anywhere on the map to take people irrespective of their rights and the rights that are guaranteed under the Refugee Convention. By the way, in condemning detention centres across the world, we must not forget the deplorable conditions of our own and the clamour of these to be closed down. Report after report has criticised our immigration removal centres, with people detained in them being subject to overcrowding, unsanitary conditions, poor nutrition, and a lack of welfare support, with very, very little safeguarding provisions. Many of you will be aware of the sex abuse scandal regarding guards at Yarlswood IRC, which groups like Movement for Justice, and I believe Karen Doyle's on this chat, have been involved in campaigning, or successfully campaigning, to close down. To think that we could be treating people who have fled persecution, war, or been victims of torture, who have escaped the clutches of traffickers in this way, explains how easy it is for this government to even contemplate sending people to countries where their rights might be further impinged. And in many cases, people who have lived in the UK for many years, including those with every right to be in the UK, such as victims of the Windrush scandal, as was so well illuminated in the case of Anthony Bryan in the film Sitting in Limbo. And he was just one such case. And we saw the government's callous disregard for life at the outset of the COVID pandemic, prompting a major public health risk in those immigration detention centres, as was clearly highlighted by a number of NGOs and written about considerably by May Bullman of The Independent and Diane Taylor of The Guardian. The bill was posited on the basis of a need to be tough and stop the people smugglers and people crossing the channel in the small boats, i.e., to stop the invasion of brown and black people of English shores. It is useful to pause at this moment to reflect on the narrative about invasions, economic migration, and illegal migration by looking at some of the actual facts. By mid-2021, there were some 84 million people displaced around the world, of which just 27 million, according to the experts in the field, and the experts aren't the Daily Mail or the Express or the Sun, or even the Guardian or the Independent, but the UNHCR, are refugees, and 5 million are people actively seeking asylum across the globe. And dear to CLS's heart is Venezuela. We know that over 4 million people have left Venezuela over the past 3 years, not necessarily because they wanted to, but because the sanctions and forced shortages by the elites and opposition forces opposed to the Bolivarian revolution and opposition forces have caused an unavoidable crisis there, which has caused people to leave. 7 million people left Syria, 2 million people left South Sudan, and over 1 million people left Myanmar. 3 million people had left Afghanistan, but there's as many as that number now on the various borders, including some 2 million said to be on the border with Pakistan. And where do these millions and millions of people end up? Not in the UK. The top receiving countries officially, as there's data of movement across the Horn of Africa missing from the expertise and the scholarship, but the top receiving countries last year were Turkey, which received just under 4 million, Colombia, which received 2 million, mostly from Venezuela, Uganda, just under 2 million, and Pakistan, just under 2 million. And we also know that if we look at Europe, Germany, France, and even Greece receive more people than Britain. We even understand, to make this very relevant to Caribbean Labour Solidarity, that Trinidad and Tobago may have received as much as 400,000 people from Venezuela. So the point and the importance of this is that 85% of people seeking asylum or who become refugees end up in other developing countries. Yet we are told that in the UK, we have a crisis, that we're being swamped. And to do this, we must implement draconian and atrocious measures which further impacts on human rights, even though the evidence says otherwise. In 2020, the UK, according to data taken from the House of Commons Library, the UK had, remember we've been talking about millions in the last minute, the UK had 29,456 applications for asylum. And even if COVID, and that was 2020, and even if COVID impacted on that, in 2019, we had just 35,737. And of the people in boats, 27,000 crossed in 2020. This is in the context of a global issue where we are talking about tens of millions of people. No one will make this perilous journey if they don't have to. And to make the journey is not illegal under the Refugee Convention, and nor does the convention require you to seek asylum in the first safe country you arrive at, as we are frequently told by those experts, the Daily Mail. So we have no crisis in the UK requiring this bill. But many of our society are convinced we have one because of the optics of the boats and the way the media plays this. The bill is predicated on the basis that the majority of people crossing the channel are not genuine. Yet according to the Migration Observatory at Oxford University, 98% of people who arrive by boat claim asylum. And taking appeals into account, over 70% succeed and become refugees or are offered some other form of humanitarian protection. Moreover, we have already seen that people are fleeing countries where there are real problems, whether these fit neatly with the definitions and categories laid out in the refugee conventions. And in most cases, it is the interference of this country and other Western countries that cause the problems that people flee in the first place. Our government is very, very keen to talk of the pull factors, such as benefits, housing, etc., but very quick to forget the push factors of which we play a major role, that of destabilizing countries. And the myth about housing, we've seen the deplorable conditions that even the people airlifted from Afghanistan are currently housed in. I'm always asked by the media why people don't stay in France if they're not just after our benefits. France pays £20 a week more in asylum benefits than the UK does. And in fact, people do stay there because they receive twice as many people seeking asylum as we do, with Germany 3 times as many. However, the media and this government concentrates our minds more than it ought to and more than we should be putting up with. And it is time that we ask questions and we protest. And the bills that you've been hearing about previously by previous speakers about reducing our rights to protest is because this government knows that it is selling us a sop, and gradually people are beginning to realize this and are not tolerating it any further. Instead of all of this nonsense and this bill, this government should be looking at the provision of safe routes for resettlement and reunion. The fact that the Afghanistan Citizens Resettlement Scheme, which only opened a couple of days ago, several months late, with an announcement that there's a pledge, or our pledge rather, to take 20,000 people, will actually include the people who are already here, shows that we're not at all serious about safe routes or family reunion. Because if there was ever a need for us to show that, Afghanistan would be the instance in which we do this with the rise of the Taliban. The fact that the government has ignored the calls from organizations like the Refugee Council to have a humanitarian visa, to enable people to apply for visas to come to the UK to avoid those crossings, is further evidence that this government is not serious about addressing legitimacy where asylum seekers are concerned, but is about rabble-rousing to its base. Before I get to clause 9, with which I'll finish with, it should be noted that the border, the bill, does contain some positive things in it. And it is such a shame that the changes to nationality law to even out some of the inherent discrimination is in this bill, rather than the separate Nationality Act or a Windrush Act some seek, given that some of the problems that were experienced by nationality discrimination were experienced by the Windrush generation and caused a lot of them to suffer in the way that they did. A lot of the work done by organisations such as the Project for Registration of Children as British Citizens benefit from the bill, and there are some advantageous changes for British Overseas Territories, though there are still problems for the descendants of Chagoans and the rights of stateless children, which we discussed with the Home Office in a consultation exercise in the middle of last year. There doesn't appear to have been any amendment there. But those are some positive things which are buried under the overwhelming horror that this bill presents us with. So there's much concern regarding the treatment of people seeking asylum, but some nodding of approval read some of the positives until November 2021, when the Home Secretary managed to blindside us all with the amendment clause 9, which effectively gives the government the power to strip citizenship without notice. The government says that this is aimed at terrorists and war criminals and would only ever be used in exceptional circumstances. This covers large numbers of us who have de facto, so that you don't need to hold a passport or citizenship papers, entitlement to some other nationality, which is most Black and brown people in the UK, but significant numbers of white people too. I think the New Statesman quoted that 6 million people could be affected, with Indians and Pakistanis being at the top of the group of people to be affected. But, you know, there's still detail that we don't yet understand. How far back do you go? Alexandra Akra, the barrister who resigned from the Home Office's Windrush compensation team, I think she was the only senior Black person in the entire Windrush team, which is another issue, but she resigned, citing racism in the policy team, warned that the government could grab hold of Ghana's right of return policy, which effectively affords citizenship to anybody who can prove that they're a citizenship, or they're a descendant rather, from someone who was enslaved. So we don't fully know how far this will go, and we don't trust this government. The Universal Declaration of Human Rights provides us with the right to a nationality, but the British government says that if you have another citizenship, the government has a right to deprive you of the British if you have done wrong. We'll end on what this doing wrong might mean. They also say it's not new, and it is true, deprivation of citizenship has been around for over a century, but it's this method of depriving you of your citizenship without notice that is the bigger concern. But the actual idea of formalizing it should be of concern to us all too, because of what we've seen with mission creep. When we first saw the deprivation of citizenship cases before that very secretive court, the Special Immigrations Appeals Commission, over a decade ago, involving people convicted under terrorism law, many said then that, you know, we'd see mission creep and we should be concerned, but it's something that doesn't actually concern a lot of us until it affects us. Then we saw the practice being used with the grooming gangs up in the north of England, heinous crimes, possibly heinous people, but it is the principle that we must be defending. I remember speaking out on radio and on TV regarding Shamima Begum, and people ringing me up afterwards and, you know, saying, well, why on earth are you doing that? You know, this is a woman who hadn't even been charged with an offence, let alone convicted of one, you know? But most people did not think this is something that would eventually affect all of us. And the government says that we will not strip law-abiding citizens. And all of a sudden, the words of Niamola started ringing in our ears. I say one thing to this government that says it won't affect law-abiding citizens, and that's Windrush. You know, try telling that to the thousands of victims of the Windrush scandal, legitimately and legally in the UK. Many of them British citizens who were forced to report, in some cases for 4 and 5 years, as I have found, to immigration enforcement centres weekly in some instances. In other cases, locked up in immigration removal centres, removed and deported. And in some cases, we know that people who have died, there are people who have died prematurely under the strain of trying to prove their status, save their houses, maintain their jobs, and look after their families. This is a government that says we must respect the rule of law when they themselves flouted it several times. And we already know that the numbers affected by the Windrush scandal aren't anywhere near those that have come forward. There are a lot of people who do not trust this government sufficiently to come forward. So the bill has had 3 readings in the House and was passed overwhelmingly, as it was, with this government having such a huge majority. And it was read in the House of Lords last week, and you all would have probably heard the eloquent speeches from many people, including Lord Dubs and even Baroness Warsi. But it will go back for scrutiny to the committee stage on, I think it's the 27th of January. And so it's really important, therefore, that we keep up our protests. This bill, not only does it affect the rights of refugees and asylum seekers and people who are trafficked, people who are all legitimately entitled to be in the UK, to come to the UK, who have protections in international conventions and treaties, but it now affects nearly all of us present in this conference here today. Thank you.
Jackie, thank you very much for presenting on that. We really appreciate it. And essentially, you presented a very, very excellent case on the realities of the Nationality and Borders Bill. Effectively, as Jackie said, the Nationality and Borders Bill doesn't just affect, Black and brown people. It affects anybody who's got a parent who basically has citizenship of another nation. So there's effectively more the reason why we all need to get behind doing what we can to tackle this from passing. Obviously, I hope that justice prevails and these acts get tackled, but essentially the reality is very stark for many of us. And I'd basically just like to thank our guest speakers for presenting excellent points on these 3 bits of legislation.